Excellency, distinguished delegates, ladies and gentlemen, I'm extremely delighted to take part in the HCCH and Codified conference as a panelist in the opening panel of the programs. The theme of the discussion, commercial, digital, and financial or codified law cross-border, is highly relevant to the digital economy of Afro-Asian states that are today deeply engaged in the fintech and cross-border commercial transaction in many integrated levels. As the Secretary of AALCO, it is my pleasure to place on record our deep gratitude to the HCCH for their pioneering work on facilitating the codification of private international law and the legal aspect of digital economy. We have cooperation agreement with the HCCH that was signed in September 2016 in Beijing, the People's Republic of China, wherein the two organizations agreed to cooperate and work on areas of mutual interest. In this regard, the codification and progressive development of private international law is a topic of deep and continuous interest for AALCO specifically and the Afro-Asian community at large. While the HCCH has been at the forefront of many topics in private international law, the theme of codified law across border is unique in many respects. The technological and legal complexity surrounding commercial, digital, and financial transactions in area of far too complex for easy answers. Legal certainty and harmoniously interpretation of law is essential for a stable and prosperous world economy. And this is all the more true in the digital economy. Even today, we are still at the nascent stage of understanding the deep techno-legal implication of cross-border transactions, and I hope that this conference will throw light on some of the many complex issues surrounding codified law across border. The field of private international law in the Afro-Asian regions had historically not attracted much prominence due to various reasons. However, I'm glad to note that this scenario is fast changing, with a large number of African states taking an active interest in this area, largely on account of rapid economic and technological growth being witnessed in many countries. Today, it is not uncommon to see lawyers and legal professionals from Asia and Africa actively advising clients on transnational commercial dealing with full proficiently in the regulatory compliance requirements that arise in such transaction. In short, it would be no overestimation to state that the future of private international law, especially so in the realms of digital economy, would be Afro-Asian centric, given the immense of potential of cross-border commerce and fintech penetration in the region. While the collective enthusiasm toward embracing a seamless world is much welcome, it is extremely important for us to be cognizant of the techno-legal complexity involved at the intersection of financial, technology, and choice of law. To begin with, I would like to touch upon the private international law implication of digital economy. As we are aware, there are a host of substantive issues in the private international law, in the domain of property law, contract law, security law, insolvency law, amongst others, that come into play when codified transactions take place across national borders. Issue of automation and artificial intelligence in the making and enforcing of contract have deep seated implications which are only beginning to be explored by private international lawyers. Similarly, the issue of digital asset is assuming important in the context of national and global fintech regulations, or rather the absence of it. Issue of jurisdiction and choice of court, applicable law, and choice of law when adjudicating disputes involve crypto asset or transaction involving blockchain do not have clear-cut answers in the present scenario, and has also been noted by the HCCH. Enforcement of judgment and award involving foreign court and generic issue of cross-border and cross-platform engagement and cooperation are quite relevant in the digital economy. While such issues remain complex, it is extremely heartening to note that giant strides are being made in the digital economy. The growth of Web3 as powered by the token economy is one such landmark development. Similarly, the widespread decoupling of crypto use cases leading to the validation and adoption of concrete use cases that are sector and industry specific have come with their own complication and challenge, notwithstanding the potential that such developments have to offer to economic growth. The evolution of from blockchain 1 to blockchain 2 and blockchain 3 is a similar trend in this regard. Each of these developments pose issue of jurisdiction, choice of law, right and obligation of parties situated in different corners of the globe, enforcement of foreign judgment and award. And the very purpose of a conference on this nature is to examine and unravel techno-legal questions that could potentially arise in this regard and brainstorm on appropriate solutions. The issue of distributed ledger technology, or DLT, which are a set of instructions and protocol on which blockchain is based, as well as the technology that created Bitcoin, is posing numerous unresolved questions to commercial players across borders. As per the World Bank, the DLT refers to a novel and fast-evolving approach to recording and sharing data across multiple data stores. This technology allows for transaction and data to be recorded, shared, and synchronized across a distributed network of different network participants. The World Bank also notes as the technology in this field is still evolving and universal definitions have not yet been formalized. The said definition may suitably describe DLT in the current context. Given its cross-border nature, the greatest challenge that emerged on account of the anonymity of user is identifying the location or the physical space of a given fintech transaction. Also, the nature of the record in DLT pose unique legal question in itself. Do they constitute property or contract, or a sui generis derivate of its own kind? Is it not exactly clear as to whether existing legal regimes can be made directly applicable for such transaction? In such a scenario, the domestic legal regimes of individual countries are often deemed to be insufficient to address private international challenge that can emerge in cross-border transactions involving DLT. And to be sure, DLT as an emerging technology has the potential to revolutionize commercial transactions. Therefore, given the fact that direct transaction within a ledger can take place without a central regulatory authority, the determination of the rights application of commercial parties in this high-risk enterprise where millions of dollars could be involved in a single transaction is fraught with difficulties. The question of how and when can a commercial offer be made and accepted? How is the consideration involved to be transacted? What are the exact contours of non-performance of contractual obligations when DLT is involved are concerned that need qualify for business and commercial confidence. The impact that blockchain has and as such has on the dispute resolutions landscape needs a greater introspection. Management of risk involved in this regard is crucial for business success, and codifying the law in this regard is absolutely essential. Legal questions like the applicable law apart, the right and liability of third parties, kinds of digital asset holders, and their right and liability remain open issue as of today. The absence of a clear dispute settlement mechanisms in the world of cross-border fintech, given the reality that most conventional judges may not possess the technological know-how of settling disputes involving deeply complicated issues, add to the urgency of creating a robust and market-friendly mechanism that ensure the rights of all stakeholders. Facilitating e-literacies amongst all sections of the society become a sine qua non in a digital economy and a digital legal system and judicial machinery with the ability to appreciate techno-legal complexity of a digital economy becomes a must. The emergence of cloud economies where individuals are allowed to own and trade digital assets as non-fungible token or NFT has led to a situation where capital controls are eliminated and monetization of digital assets are possible in the physical world. The difficulty of alternating data in blocks, once record and peer-to-peer transaction in interconnected block, where the objective is to do away with a central intermediately post-legal issue in our existing framework, where such transactions are normally routed through and immediately and intermediately. Our fintech legal framework currently in place appropriately situated to address legal questions involving AI-based transaction and cloud services. Much to our disappointment, the answer may be no, but it gives us to the ability to create a transaction legal regimes under the leadership of the HCCH to address such concern. A peculiarity of the digital economy is that while commercial transactions are increasingly getting decentralized, the legal system of a country remains centralized. This inherent mismatch between the bottom-up and the top-down legal system is the precise challenge that has to be addressed if codified transactions across borders have to become seamless and predictable for economic growth. It is here where the HCCH and other like-minded organizations like AALCO can play a strong collaborative role in helping states navigate to complex maze of fintech legality. A question that is normally asked in today's fintech context is the private intellectual implication of cross-border data transaction. The question of collateralization is yet another question with its own complexities. In this regard, I note the finding of the ANSI trial that contract for the provision of data are analog to contract for the sales of goods, and contracts for the processing of data are analog to contract for services. Needless to mention, this could have implications for determining the applicable law. untouched position in this regard is that cross-border data flow are distinct from both goods and services, and thus should be considered neither e-commerce nor trade, which has deep-seated implications for such transactions. It is for private international lawyer to unearth the real-world implication of positions adopted in this regard. At this juncture, I note and deeply appreciate the effort of the Ancestral and the UNIDROIT in promoting a deeper understanding of private international issues in the realm of digital economy. I take this opportunity to note the impact of the HCCH Convention on digital economy. The HCCH 1985 Trust Convention is the first and foremost in this regard. The convention helps to determine the applicable law that provide for rules to govern issues pertaining to the trust. Usually, the law will be chosen by the seller, and in the event that no law is chosen, objective factors like trustee place or business may be used to make the determination. Also, the Commission deals with the implication of governing trust in other jurisdictions. All of this brings about a great deal of legal certainty to fintech transactions and safeguard the asset of parties in non-trust jurisdiction. The HCCH 2006 Security Convention is also significant in this regard. Whereas historically, security were represented by hard copy certificate and physical entries in book register. Over the last century, we have seen that new method of holding security have come about. Chains of intermediaries execute debit and credit to securities account. While these intermediaries no doubt provide efficiency in commercial operations, the fact that they are not based on physical certificate and hard copy register pose question of legal authentication. Also, as these intermediaries are likely to operate in multiple jurisdictions, the law of different states may stymie commercial transactions. Thus, what may be legally permitted to one in one jurisdiction may not be so in another jurisdiction. By giving priority to the express agreements between the account holder and the intermediary, the issues falling within the scope of the convention are protected to safeguard the interests of the stakeholder. However, questions like blockchain, ledger, actually qualifying as intermediaries pose challenge and need to be appropriately addressed. The 2015 Principle on Choice of Law in International Commercial Contracts were the first soft law instruments of the HCCH and were aimed at promoting party autonomy in transactional commercial transactions. The principle were considered as a landmark in reforming the domain of choice of law in codified transactions. The 2015 principles have been widely accepted as a basis and model for national and regional effort in uniformly structuring international commercial contracts. The harmonization efforts have been accepted by Ancestral and the International Chamber of Commerce, amongst others, and have paved the way for the creation of a predictable business environment in the digital economy, and challenge ahead for the Afro-Asian regions. There are specific challenges facing the world of private international law in the context of transnational codified transactions. Some of these issues are relevant for Afro-Asian states, and I would like to highlight them before I conclude my address. First, assessment of national legislation on transnational codified transactions. As a first step, It is important for states to make an assessment of the existing legislative and executive framework regulating transnational codified transactions. It is possible that many states do have legislative framework governing codified transactions. However, whether these laws are internally streamlined and consistent with the law of other countries so far, so as to facilitate uniformity and consistency remain a question of debate. In this regard, I urge all states at a primary level to make an assessment of existing legal frameworks with essential comparative analysis of similar jurisdiction in this domain. In addition, this exercise should also capture the state of law reform happening in this field and effort being made to harmonize laws in accordance with HCCH framework. To give an example, is countries in the process of modernizing the national choice of law rules in contracts, and the process is drawing from the 2015 principle on choice of law in international commercial contracts. A second, linkage with arbitration center and the arbitration community. It is important for state and international organizations to work closely with arbitration center and the arbitration community at large to understand that response to the emerging international legal landscape on transnational codified transactions. The receptivity of arbitration center to the global legal framework has a direct link with their acceptance with the dispute settlement framework governing such transactions as regard private parties. In this regard, it is important for states to assess if arbitral institutions under their jurisdiction have incorporated global frameworks in their institutional rules. Endorsement of framework like the 2015 principle from the Arbitration Center would go a long way in creating a harmonious legal framework in this regard. 3. Clarity on public power and private autonomy dimension of transnational codified transaction. At present, a great deal of confusion exists on the legal nature of certain HCCH instruments. The HCCH 2006 Securities Convention is a case in point. Many stakeholders believe that the domain of public law enforcement, including money laundering, fraud, cheating, and tax evasions, would get adversely affected if private parties are given the autonomy to create transnational codified transactions. However, this view is based on fundamental misunderstanding, as none of the HCCH instruments have ever sought to limit or curtail the power of the state to enforce police power where violation of domestic law are concerned. The same is also true in the debate surrounding offshore trust jurisdiction and their possible relation with the HCCH 1985 Trust Convention. It is important for all stakeholders to revisit the interlink between public power and private autonomy to better understand the nuanced relationship between the two and facilitate a harmonious international private order where both public power and private autonomy coexist. In this regard, I suggest more capacity developments initiated and be initiated to clarify complex issues in this domain. Fourth, increasing the visibility of the HCCH instruments. Among the most important challenges facing the Afro-Asian regions in the world of transnational codified transactions is increasing the visibility and reach of HCCH instruments. While it is not necessarily a concern limited to the Afro-Asian regions alone, it is generally accepted that increased interface and synergy between the HCCH and the Afro-Asian regions is an issue that deserves attention as harmonization of codified transaction can lead to a more stable and predictable business environment. This is even more important given the reality that most Asian African states have today invest themselves in creating an international economic order based on freedoms and private autonomy with all necessary precautionary safeguards. In this regard, I would urge both the HCCH and the Afro-Asian community to come together for achieving this purpose. AALCO is ready to act as a necessary catalyst in this regard. As I close, I wish to place on record my sincere appreciation to the HCCH for their systematic effort in creating a predictable and stable legal environment for codified transactions taking place globally. Needless to mention, these efforts have gone a long way in addressing some of the major concerns facing the world of fintech. It is also important to note that a lot of work still remains to be done in addressing emerging techno-legal challenges, including question of jurisdiction and choice of law in newly emerging fintech platform. It is my hope that this convention will be a highly used one in this regard and pave the way for deeper international private law reform and grow in the domain of CODIFI. I'd like to once again to thank the HCCH for giving the opportunity for AALCO to join this very important event.